Hello, and welcome to the Fort Jackson Legal Assistance Office. I am Captain Reyes, and today we're going to talk about why you should create a will and/or possibly an advanced medical directive. This video does not substitute for legal advice, and if you require legal advice, please schedule an appointment with the Fort Jackson Legal Assistance Office. What is a will? A will is the legal declaration of how you would like your property distributed in the event that you were to pass away. It is beneficial to have a will because it reduces the stress and responsibility on your family that comes with the loss. A will allows you to prepare for the future and take care of your family should something happen to you. With a will, you can decide how your property will be distributed and who will receive it. You can also choose a person to manage your estate or distribute the property you own. This person is labeled the executor or personal representative and will have the authority to carry out your wishes under the state probate code. If you have minor children, you can also appoint a guardian to care for them should something happen to both you and your spouse. You will also be able to express your desires regarding funeral arrangements and whom you will want to handle that responsibility. If you were to die without a will, you would die intestate, which could become expensive for your family. Oftentimes, the cost of administrating an estate without a will is more costly than if the person had planned the estate with a will. Additionally, without a will, the state's intestacy statutes would determine who gets your property. Although the property would not go to the state, the court could appoint an administrator from persons designated by law to manage and sell the estate. Bonds may be required by these court-appointed agents and may delay the process of executing a will. There are limitations to having a will. A will does not become final until the death of the testator, and it may be changed by drafting a new will. In some states, a will cannot be altered by writing a change into the will after it has already been signed. In fact, writing on the will can have the potential effect of voiding it. Furthermore, certain changes in life circumstances can revoke all or some portions of the will, such as marriage or divorce. In any case, it is always a good idea to have a will whether you are entering the Army, deploying, having a child, or retiring. Next, we'll talk about the Advanced Medical Directive and/or Healthcare Power of Attorney. At the same time you and your lawyer prepare a will to distribute your property, you can also request documents that declare your medical treatment wishes if you are no longer able to make a decision regarding your end-of-life care. Under the law, a person is entitled to make their own decisions concerning medical treatment, and he or she has the right to accept or refuse medical care. No one else has the right to make these kinds of decisions for you unless you have been declared incompetent or incapacitated. Considering these circumstances, it is beneficial to request an advanced medical directive and a healthcare power of attorney. First, an advanced medical directive, sometimes called a living will or desire for natural death, is a written declaration in which you state your wishes about the use or non-use of life-prolonging care if you become terminally ill or in a persistent vegetative state. With an advanced medical directive, you can make a declaration stating whether you want to have life-sustaining measures withdrawn should you be unsound or unable to make the determination at that time. This directive can reduce the stress placed on your family in making this difficult decision. In contrast, a healthcare power of attorney is a durable power of attorney that deals with healthcare planning. In a healthcare power of attorney, you appoint someone to make healthcare decisions for you, including making decisions about surgery, personnel, and treatment plans. A healthcare power of attorney is broader than an advanced medical directive and enables your family member to make medical decisions should you become temporarily incapacitated. Lastly, a springing power of attorney functions similar to a general power of attorney. However, it does not have any effect until an incapacitating event occurs. It is at this incapacitating event where the power of attorney would begin to have effect, and thus the power of attorney would spring into action. These documents can all help you prepare for the future and reduce the amount of stress and discomfort to your loved ones that comes with the loss. If you would like to set up an appointment to meet with an attorney to prepare any of these documents, please call the Legal Assistance Office at 803-751-4287. Thank you.